Hi and welcome to the Groot report. My name is Kate Varco. I'm a Senior Associate here at Groot and I head up the Estate Planning and Estate Administration departments. Today I just wanted to touch very briefly on a determination of the Superannuation Complaints Tribunal which was handed down earlier this year. The determination is not necessarily a seminal one and there hasn't been much commentary on it, but it is important and relevant in my view insofar as it echoes the approach that has been taken by the Supreme Court a la Munro and Munro in relation to the notion of strict compliance when it comes to superannuation funds and observing the rules of those funds strictly. So look, in this case, which is D14/213, the complainant was the alleged de facto spouse of the deceased member. She brought her complaint before the tribunal on the basis that the trustee of the super fund had erred in finding that she did not meet the criteria of the super fund in terms of her eligibility as a de facto spouse and therefore dependent of the deceased member. In reaching its decision, the tribunal agreed with the trustee, not because on the evidence before it, the relationship between the deceased member and the complainant didn't have all the usual hallmarks of a de facto relationship, and the tribunal in fact acknowledged that in other circumstances, having regard to, for example, the rules under the SIS Act, the complainant may well have been found to be the de facto spouse of the deceased, but it agreed with the decision of the trustee due to the very unique and specific criteria which was set down in the superannuation deed, which set out the eligibility criteria for a de facto spouse and therefore dependent of the deceased member. So look, in this instance, in my view, the case highlights two things. One, the tribunal was not willing to take a more expansive or liberal view of the requirements which were set forth in the superannuation trust deed, and therefore they required or applied the doctrine of strict compliance in this case, even though the outcome may not have been one which the deceased would have actually desired. And two, it highlights for practitioners the need to read the deed and never make any assumptions about what may be in a deed, especially in relation to the definitions of who might qualify on the death of a member to the death benefit entitlements of a deceased member. Thank you for listening to the Groot report today.